great episode of The Presumption. Hi, guys. Jim and Matt.
Hey, Sarah.
What's going on, Sara and Jim?
How's everybody doing?
Hey, I'm good. I am back in the office. If you've been watching us lately, you've seen me from all different sorts of backgrounds. But
right. We've heard the birds chirping.
Let me tell you, as an audio editor, I have had my work cut out for me. There have been so many thunderstorms, dogs, cats. It's been wonderful. Let me just say. It's been a pleasure.
All right. Well, so we got Jim and I have to talk about Hunter Biden, which, look, this is not a political platform. It's a crime platform, but we did cover Hunter Biden's plea deal that we were expecting it was struck, but we were expecting a change of plea hearing. And that happened. And so obviously crime is crime, even if your father's the president. And so Jim, it's very interesting because I thought about you when I first read that this fell apart. I think I even texted you because you and I were saying that when we covered this, there must be some language in there regarding immunity that essentially says that this investigation of him is over. It's been 5 years, that he's not going to have any other problems hanging over his head. And so what happens?
Yeah. I mean, we've covered this a couple times. One, I said that the Trump indictment was really bad news for Hunter Biden. And then right on the heels of that, we had the Hunter Biden plea deal announced. And I said, wow, that's a great deal for Hunter Biden because he's given a pass on any investigations. But you pointed out, well, we haven't seen the plea agreement. Well, guess what? There's a plea agreement and the U.S. attorney doesn't agree with Hunter Biden's lawyer as to whether he gets a pass going forward on the other matters that he's under investigation. And damn, I mean, you would have thought that
look, you and I
would have come up before standing in front of a federal judge.
Right. And like you and I, we practice in federal court. And when you negotiate a plea agreement, number one, you go through many drafts before that plea agreement is finalized. There's a meeting of the minds. Every word can make a difference. Every word is negotiated. Now, some of it is standard, giving up your constitutional rights, your appellate rights, whatever. But for the most part, there are things that are nuanced in a plea agreement that are really, thought that the big part of Hunter Biden's plea agreement is exactly what Jim is saying, is the idea that he gets some form of immunity, or there's at least the plea agreement can't be silent with respect to that. It either needs to say he's covered or he's not covered. You can't just kind of leave it silent. And so that is why the judge did not accept the plea yesterday. And it's not that she's not going to, it's that she's basically told the parties, you guys go finish this job because this is kind of half-assed, right? And also, Jim, the judge, and I don't know if it's like this in South Carolina, but we do have judges here in the Central District of California that don't like the federal rules of criminal procedure 11C1C, which essentially binds the judge. Typically, sentencing is up to the judge.
Yeah, break that down. Matt,
so
we're not talking about a gate at an airport. We're talking about a rule of criminal procedure.
We're in a zone.
We're in a zone. Rules. I don't know. I'll try to pay attention.
So typically, sentencing is up to the judge, who can go below the guidelines, above the guidelines, just can't go beyond any statutory maximum. But this rule, which sometimes it benefits us to negotiate it into a plea agreement, kind of like what Hunter did with the government, essentially binds the court to what the parties agreed to by stipulation on the plea agreement. Judges don't like that.
Yeah, so the judge's decision is either accept it or reject it. The judge has no discretion other than accept or reject. And judges don't like that. Don't like it at all. And
they want to give notes. Is that the idea?
Well, the judges want to weigh in on what the sentence is or the resolution.
Yeah. I mean, that's what I mean. Like, they want to have a direct impact as to what the decision is going to be.
That's why they get appointed, and that's why they are in the third branch of government.
But I brought this up for us to address, and we'll move on because we have another story to cover. But essentially, because there's been a lot of noise on Twitter about why this deal fell apart, or it's not that the deal fell apart, or why the judge did not take the plea yesterday. It's not because the judge is saying anything about the nature of the deal that's struck, like it's a sweet deal or it's a terrible deal, or all this stuff that people are saying. It's BS. Okay. Whether you think that Hunter Biden got a sweet deal on possessing a gun as a drug user for 11 days or not, or whether you think he should have gotten the hammer harder because of a $200,000 tax laws, you're entitled to your opinion, okay? But that is not why his plea agreement was struck down or not taken. His plea agreement was not struck down. His plea was not taken. Basically, the judge said, you need to go have a meeting of the minds with respect to immunity and his future exposure, because he is being investigated for FARA violations, and then come back. So it's put on hold, right, Jim?
That's correct. Okay. Now, Sarah, you and I both have done this plenty of times. I've had many situations where you don't really want to put it in black and white in front of the judge as to actually the full scope of the deal. You just have an understanding with the prosecutor. Right. But you don't do that with the president's son and everybody in the world watching. And the judge, kudos for her asking the right question. Is he subject to being criminally prosecuted in the future? Yeah. And, whether the U.S. attorney had led Hunter Biden's lawyers to believe that he was not, but when pressed in open court, the U.S. attorney said, sure, he's subject to prosecution in the future. And as I read it, Hunter Biden's lawyer said, we have no deal then. So something went awry, and we'll.
And I also don't see this, Jim, as a political thing. People say, oh, the judge is a Trump appointment. No, I think what the judge did is absolutely also in Hunter's favor, too. She wants to make sure that there is an understanding. I mean, that's for both sides, and it's really for herself, but it's for both sides, because you just don't want to leave something like in a very high profile plea agreement that's so political, et cetera, being the president's son. You don't want to leave something like that out there that's not addressed. So that's the only reason his plea was put on hold. Can we move on?
Let me throw one more point in. I was on a plane with Senator Lindsey Graham recently, and we're talking about Trump judges that were appointed in South Carolina. I think people need to know Trump doesn't choose the judges. It's the home state senator, the senior senator from the home state. And I was complimenting Senator Graham on what great judges were appointed when Trump was in office in South Carolina. And that may not be the situation across the country, but it's really the senator from the home state where the judge is has a lot of say in who gets appointed. So I don't know anything about the judge in Delaware, but to say he or she is a Trump appointee and you should discount that person is just wrong. I mean, it's totally wrong.
I know. And listen, I don't know about you, but I'm looking at this strictly from a legal lens. I really am not, people are saying Hunter's a dirtbag. So, being a dirtbag is not a crime. Okay. You can be as dirty as you want to be. But at the end of the day, I'm looking for the evidence of crime. And all I've been saying, I've said this to you before too, is that I'm sorry, but if I had a client come into my office saying that they were a narcotic offender, no violence in their past, and they possessed firearms for 11 days, I would first kind of chuckle, and then I would pick up the phone and call the U.S. Attorney's Office. Of course, I would take it seriously. But I mean, in the spectrum of what we deal with, come on. I maintain that if his last name was not Biden, he would not have faced these charges. The tax thing would have been deferred to civil, because it wasn't like he, didn't disclose his income or like failed to, was like doing all these illegal deductions or anything like that. It's just he didn't file returns, right? Which is very different from this sort of scheme of misreporting your income and other kinds of tax fraud. And the gun thing, in the spectrum of firearms violations, people that are felons that should not possess firearms, people that have a violent history that should not possess firearms. This is, again, it's not the same level of severity. So if we're going to talk about politics, then I'm going to tell you, if his last name was not Hunter, after 5 years of investigating China, he probably would not have been before this court. Period. Okay. What else we got, Matt?
Well, we do have a great guest interview coming up for you guys. But before we get to that, we do have a crime time that I wanted you guys to talk about. It's right in Sarah's backyard, so I feel like she's well equipped to discuss this case. So it's a high-profile murder trial, and it should be making national headlines, but somehow it's not. It's a love triangle murder, which, let's face it, we all love triangles. Maybe not the murder part.
We all love triangles.
The guy at the center of this, the victim, his name is Fabio Sementilli, and he's an Italian from Canada, or rather he was, very jolly, happy executive at a food wellness company, or excuse me, it's called Wella, but it's a hair care company. I put up a picture of him and his family. So he moved his family, that's him with his wife, Monica, and their 2 daughters to Los Angeles for a job. And they were living in Woodland Hills. And he was stabbed to death in his own home while his wife was out shopping. And moments after the stabbing, while he was flailing around and dying, his daughter walked in on the scene, which must have been traumatizing. And the assailants were seen on camera entering the neighborhood and then later leaving. Fabio's car was found abandoned later. And then it turns out that one of the assailants resembled the wife's secret lover. His name was Robert Baker. He was a registered sex offender, a former porn star, and he was also apparently at some point an investigator in the military. I can put up a mugshot of them in a minute here. But before I do that, let me just say there's overwhelming evidence in the case, tons of DNA. This guy's DNA is found in the car. Blood is found in Fabio's car. He had an injury to his hand, and basically the evidence against him was so strong that he pled guilty, and he's got life without parole coming up. And the question is really, Monica's going to trial in September. Why would this guy not also try to go to trial? So, Sarah, I know you know lawyers on both sides. What do you think about this?
So, yeah, Jim and I actually have talked about this because I was like, Jim, you have to read about this case, because I was surprised that, with the true crime community being all about these sort of love triangles ending in murders, why we haven't really covered this. Very interesting. On the defense side, Jim and Matt, Leonard Levine, he's been my co-counsel on a number of cases. We've tried cases together representing the same client. I mistakenly call him Leonard Cohen in front of I don't know why, but because Levine and Cohen are both Jewish last names, and they're both legends. I think my colleague is a legend, but I use a musician's name on him. But anyway, and then Blair Burke, who's the celebrity attorney here in town, and then on the DA side, it's brutal Beth Silverman, we call her Brutal Beth because she's just relentless. And it's a good, it's a good solid team on both sides of this case. But the thing that I want to really kind of flesh out for people with Jim is the idea that, and then this started with even Baker's own lawyer, the idea of, oh my God, he needs to go to trial. He's facing life without parole. Why would he fold and just plead to life without parole? And I just want to say that people plead for many different reasons. It's their right to go to trial, and it's their right to give up that right to go to trial. So, Jim, have you had a client where you really believe the guy should go to trial and he's like, no, bro, I don't want to go?
I can't honestly think of one off the top of my head.
Okay.
But, there's a lot of reasons why this guy, may want to just plead guilty. And I think perhaps the most logical reason is he wants to testify for his former lover.
Yes.
And try to exonerate her. And
yes.
and maybe he feels some guilt that he got her involved in this.
Yes.
And, he's willing to take it to his grave. Who knows? I can tell you, my understanding has been in a county jail for 5 years.
Yeah.
Which is not a pleasant experience. A county jail's incarceration is completely different than state penitentiary. And
he's been, Jim, in LA County Jail through the pandemic. Okay. Those are some horrible, I mean, it's horrible anyway, but those were like really horrible days. He's been in LA County jail. The evidence against him is really overwhelming. On camera, the guy really, one of the assailants really looks like him, even though he's covered up, in terms of his like body type and everything. It's his blood in the victim's car, right, which was found a few blocks away. So he's charged with murder. She's charged with conspiracy to murder. And unlike the evidence against him, the evidence against her is bleak, right?
Yeah.
And so, like you said, he's probably thinking to himself, okay, yeah, I might have a little chance of like hanging the jury or whatever, but do I want to do that? Or at this point, do I want to at least save her because I got her into this mess too? You know what I mean? And
that's what it looks like. He's also seems to be protecting someone else because on the video, there's 2 people running away.
Yes.
And 2 people.
That's what I was going to say. Have they even talked about who that second person might be?
No, they don't know who that is.
They don't have a clue who that person is. And,
yeah.
And so, that I guess Baker had an opportunity to cooperate. I mean, he could have fingered his co-assailant, I assume, the guy who went in with him. But my understanding of the evidence, though, is Monica gave Baker, information on how to access the security camera, how to take, steal the tape, and so that was missing, and that they've got that on her. Whether that meant she intended for them to go in and kill her husband.
But Jim, you know what she has going for her is that there's evidence that she was aware that her daughter was going to be home around that time. So the daughter's going to testify. And she is not like Lori Vallow. She's not like some monster. She's actually very sympathetic, is what I'm told by another lawyer that was involved in the case. So, so why would she, let's just say that she planned this killing. She would never do it at a time where she knows her daughter would walk in seeing her dad Slate, right? So there's, and there's, as there's obviously some explanations about the email, about the security camera and whatnot. They were lovers and, I don't know, maybe she wanted him to like watch her have sex with her husband. People are sick. Who knows? I mean, he was a porn star, right? He was a porn star. So who knows? But it can be explained. But one thing that I find curious is that, she's just been sitting on ice for 5 years. And that does not, in my mind, indicate that she is chomping at the bit to go to trial to prove her innocence. I mean, she's been sitting on ice for 5 years. That's a long time to be sitting in the county jail. Yeah.
I mean, her lawyers are not rushing her case to trial for a reason. I mean, I guess.
Well, she's supposed to go to trial in September, but there was a big discovery dump. So I don't know if that's going to delay the case. But what was interesting is at the sentencing for Baker, the co-defendant who pled, there was a lot of obviously victim impact statements. His family from Canada, his son from a previous marriage. And then Beth Silverman, the DA, gives the floor to her daughters who are victims of their dad's murder, but they're the same DA that's giving them the floor is trying to put their mother away in prison on LWOP. I mean, it was just, it's kind of surreal, right? When you're dealing with, when you're dealing with,
I had that.
A family, right? And I mean, in your case, Buster did not make, nobody from Alex's family made a victim impact statement, but everyone was on pins and needles going, wait a second, what, like, is he going to make a statement? His brother and mother were murdered, but his father is being put away. So like, would he do this? It's very interesting when you're dealing with families.
Yep.
All right.
So the trial coming up will be very interesting. Will Monica's lawyers call Baker to the stand? I mean, he has no Fifth Amendment privilege anymore now that he's pled guilty to those offenses, I suspect.
That's what they're planning on doing. And I think Lenny Levine, not Cohen, in a presser after Baker pled, essentially said that in so many words that they're relying on him to testify. That
do you think Attila the Hun that you're referring to as the prosecutor, that she'll offer some
Attila the Hun.
lesser charge plea,
I don't know.
Jaywalking
They'll take, obviously, but
right.
trespassing, trespassing on our own house. No,
criminal and domestic violence, first degree.
She wasn't even there. I mean, it's it really, the only thing that meets the factual basis here is conspiracy to murder, and that carries the same penalty as murder. And so it's like, I think this happened. This is our central courthouse in the county. It pulls a really fair jury. It's a good courthouse to have a trial. It's the same courthouse as OJ and all those trials. And these are great lawyers. I mean, Lenny's a great lawyer. Blair doesn't really litigate, but Lenny's going to do the trial, and he's a great lawyer. And I just think, the evidence is, I don't want to say there's no evidence, but certainly nothing forensic, and anything that's there can be explained. And I just don't see how 12 jurors can all say, oh yeah, she conspired to have her husband killed. Maybe she was thinking about it or hoping it would happen, but like not at a time where her daughter was going to walk in on her father. Right. I mean, that just, anyway. But I think that's all we got for crime time, right, you guys?
For now, but of course, we will keep you guys updated on this case as it progresses, as you guys were saying. And I mentioned before, we do have a great interview coming up with Dr. Jeff Whiting. Just a freaking fascinating guy. I think you guys are all going to really enjoy that conversation. Just a production note, when we recorded the episode, he was basically on a 3-second time delay. I fixed all of that, so you're not going to hear that. But if you're watching it on YouTube, you might see some white flashes. And I just want to let people know, you're not missing any content. It's just literally dead gaps to make it more easy to listen to. So I want to let people know that.
That sounds like fun too.
Oh, well, listen, we put a lot of care into these episodes because the content's really important. And we're all really grateful for everyone who's listening. Please subscribe if you're not already. As you know, we're on all the podcast platforms. You can watch us on YouTube, youtube.com/@thepresumption. And that's our handle for all of our social media tags, Twitter or X Twitter. I don't even know what they're calling that thing anymore. We're also on Instagram.
Don't get me started.
Yeah, it's a mess, but whatever. We're going to be here covering crime for you guys. So we're going to take a quick break, and we'll be right back with Dr. Jeff Whiting.
Stay with us. And welcome back to The Presumption from a brief break. I'm Sarah Azari, joined by Jim Griffin, my co-host, and Matt Fondelier, and Dr. Jeff Whiting. Welcome, Jeff.
Thank you. Nice to be here.
So, I say every guest that comes on so far, I've been saying we have a special guest, and everyone's special in their own way. But Dr. Whiting is special because for the last 2 decades, I and my clients have benefited from your excellent work as a forensic psychologist. And, this podcast, this is the main reason why you're special, is one of the reasons why Jim and I started this podcast is to shed light on mental illness and addiction in the criminal justice system. And Jim recently had the Alec Murdaugh trial. Alec was heavily addicted to opioids. A lot of myths were on full display with respect to his addiction. And so, you actually are our first guest with respect to that, that angle of the podcast. So for those who don't know Jeff, I just want to briefly introduce him. He's a clinical and forensic psychologist who's been practicing in Santa Monica, California since 1983, beginning in 1985 when he was first invited to assess a defendant in a criminal proceeding. His practice began to shift from providing treatment for individuals like adults, couples, and families to one of generating psychological assessments for people charged with crimes in both state courts in California and then federal district courts around the nation. In the last 25 years, while continuing to maintain a small therapy practice, 80% of Jeff's work has been devoted to forensic cases. Attorneys primarily utilize his reports to assist in plea negotiations and or sentence mitigation. Mental disorders and addiction diagnoses are routinely found to be present, Jim and I know this really well, in our clients, and in many instances provide some explanation, even if they're not a defense, for the offense conduct. The type of cases that Jeff has consulted on range anywhere from a minor misdemeanor like shoplifting to murder, financial crimes, child pornography possession, drug trafficking, domestic violence, tax evasion, and DUIs describe a representative sample of Jeff's cases. He testifies in court on average about 6 times a year and has assessed well over 1,000 criminal defendants in his career. I don't know how many of those are mine, but there are a lot of them are mine. In the rare moments, he is not helping lawyers and their clients out. He enjoys spending time with his wife and adult children, vacationing with his wife and dog, and riding his bike. And thank God that Jeff has no plans to retire in the near future, as he continues to find people fascinating and the forensic field challenging, with much more to learn. So amen to that. We have a lot of questions for you, Jeff. Jim and I call this the forgotten disease, right? The idea that there's a real presence of mental illness and addiction in the life of somebody who's accused of crime, of some wrongdoing. Is it given the weight that it deserves in your experience in the criminal justice system?
I don't think so. I think that's one of the reasons I'm hired, to make an attempt to inform the court and to inform prosecutors some characteristics of the defendant that they wouldn't otherwise know about, or maybe if they know something about, maybe to punctuate it and underscore just how important and how significant a mental health disorder, a drug addiction, an addiction to something else is in the life of the defendant. And then, most importantly, when we can, to draw a nexus between that mental health disorder and or that addiction and the offense conduct. So I by definition, in the cases that I get involved in, I have a wonderful group of attorneys, including Mrs. Zari, who tend to be fairly psychologically minded. So they think about psychological factors in the lives of their defendants and their clients. And so I end up getting referrals that are almost always ripe, meaning there's something there. And I don't very often have to do deep sea fishing in order to figure out at least something in the defendant's life.
Jim, I'm curious. I'm sure Jim feels the same way. Jim, have you had a situation where there's something not right with your client, you just don't know what it is?
Oh, sure.
Yeah.
That happens all the time.
Yeah, and that's why Dr. Whiting is so vital to the work that we do, because
and Dr. Whiting, I'm sure you're faced with people who are not charged with crimes are very reluctant to open up about a lot of their deep-seated issues that they don't want the world to know, and I guess you experience that when someone is retained to evaluate a defendant and is trying to help them. I guess that's one end of the spectrum. The other end of the spectrum, I guess you have people who are making things up about, things that may or may not have happened in their past to justify their current behavior. How do you sort that stuff out?
It's a challenge sometimes. There are cases that are rather straightforward. We have an inkling of what's going on with the client. Maybe they've had mental health treatment in the past. Maybe they've had addiction treatment in the past. Those are a little more straightforward. I think we still like to flesh out more details that humanizes the client and helps the court, helps the prosecution, again, understand the humanity of what we're dealing with here. But yeah, it's tricky when the client, the defendant, doesn't understand why we're doing a pretty fast, pretty intense psychological study on them. A colleague of mine and I call this, getting it. Once they get it, once they kind of understand, we're going to go pretty fast. Things are going to be pretty challenging, and it's time. Time is of the essence, so we're going to have to move. Sometimes the intensity of having a criminal case looming makes it easier. I tend to have, compared to my psychotherapy practice, historically, my forensic practice across the board is usually motivated to work.
Right.
And that's quite gratifying. I think that's one of the reasons I moved toward this area of law and practice of psychology, because
When
it
you
was
say
very gratifying.
fast, when you say fast, you mean because of, we're dealing with the clock of the criminal justice system, right? In other words, you
Absolutely.
have a trial coming up, or you have plea negotiations, and I found it interesting, Jeff, that you and I do the same thing. Jim does the same thing. You said substance abuse and mental illness, two separate things, but my question is addiction a form of mental illness? Is substance abuse a form of mental illness? Because a lot of the times I'm confronted with, you and I are working on a mental health diversion case right now. And it's like the court, it's almost like if we just address the client's substance abuse, they're not going to say, okay, he's not addicted, but they'll say that's not enough of a diagnosis. So we have to look for what else may have led to the substance abuse. So to what extent are underlying mental illnesses, or like what we call dual diagnosis, related to substance abuse? And is substance abuse a form of mental illness?
Well, let me answer the last question first. Yes, it is. I mean, there are a host of addictions listed in the DSM-5, which is the diagnostic manual we're still using in my field. So it's considered a mental illness. There are many ways to think about this. The way that I like thinking about it is to hypothesize when the presenting problem is a in-your-face addiction problem, whether it be pornography, would it be gambling, outrageous spending, and then all the substances. Those are I believe, disorders, diseases in and of themselves. They have a life of their own. They tend to reinforce behavioral patterns. But oftentimes, the defendant client gravitates toward an addictive behavior as a means of coping with symptoms of a mental disorder. The mental disorder in some cases comes first. I can think of a couple cases I have right now where that's going on. It's unfortunate because depending on the severity and the length of the addiction problem, it can mask significantly what the underlying mental health disorder is. You may not see the symptoms of depression. You may not see the symptoms of mania, at least in full bloom, if somebody continues their addictive patterns. So during the assessment process, of course, we like our clients to be clean and sober, so at least we can get a crack at them in an unadulterated fashion. But it's tough. These disorders, sometimes they occur by themselves, or maybe I'm just not talented enough to figure out what came first in terms of mental disorder. But but most frequently there's something underlying when you see an addiction pattern. It
And
depends
so
on where.
what you're describing is self-medication, right? Instead of, and
Yes.
at times that underlying mental condition requires medication, like depression, anxiety, for example, has medication. And if you're not on the right medication, I live in downtown LA, so I see this on the streets. When you're not on the right medication, you gravitate towards drugs, right? Right, and so then you become dual diagnosis.
Yeah. I mean, it can be multi-layered, multi-faceted problems. Um, but normally the strategy we take is, and I think many defense attorneys understand this, we've got to get the client clean and sober. And then and only then can we begin the assessment process.
Mm-hmm.
And at that point in time, we might be thinking about some sort of dual diagnosis facility or treatment program where simultaneously they're receiving treatment for, let's say, a mood disorder and an alcohol addiction, maybe.
What is fascinating about what you do and absolutely critical to what we do is that, I mean, this is 2023, but when Jim and I go to court and we have a client, let's say, I mean, this came up in a case that you worked on before Judge Wright, district court here. My client was an alcoholic. He was a legitimate gambling addict and a pothead. And the judge who actually runs the drug, at the time was running the drug court program or whatnot, basically said that those are not real addictions. That if we were talking about a hard drug like heroin or meth, then yeah, he could see those being mitigating factors. But this was not really a big deal, right? And so it's incredible because especially in cases, Jim, where your client is charged with an offense that is not drug related, it's an offense that is, I don't know, like the robbery or something. It's like we have to have somebody like Jeff draw that nexus that but for this person's addiction or mental illness, they would not have committed the offense. I mean, I think it's easier when you're dealing with a guy on the bus who's schizophrenic, who thinks he's going to get attacked and then gets violent, like attacks the bus driver, right? I mean, you can kind of, that makes more sense to courts, I think. But there are a lot of instances where people have stuff going on that, but for those things, would not have engaged in criminal conduct. And so, and unfortunately, not every defendant can afford getting somebody, not that Jeff's like extremely pricey, but still like hiring that kind of resource. And the counties don't offer people like Jeff to do that kind of assessment. It just doesn't happen.
I have a question, sort of a layperson's question about the sort of mental health assessment process. You said something a few minutes ago about how we have to wait until this person is like sober and is sort of like in a clean state of mind before the assessment can begin. But I'm just wondering, is there really a reason behind that? Would there not be valuable information to be learned assessing somebody when they're in the throes of, whatever caused them to be in your presence in the first place?
Like when you're drunk, they say you tell the truth.
Right, telling the truth.
Yeah, I mean, I guess that's one way to look at it.
Give them a little bit of LSD and let's see what comes out, right?
Sure, it's a little more experimental than what I was going for, but I just wonder if, you have somebody who's, who is under like severe drug use and, maybe you could learn something talking to them in that state, or is it just all at that point just nonsense from a psychological perspective?
Most times it's nonsense.
Okay.
Yeah.
You've been watching too much Cheech and Chong, Matt.
Yeah. Well, listen, I come from the perspective of being more like as a true crime writer. So I'm just always thinking about the dramatic scenes in my mind, not really the realities of it. Anyway, I'll shut up now. I just wanted to know.
Yeah. One thing I'd like to address, Dr. Whiting, and the work that you do is extremely valuable in mitigation and explaining and trying to resolve a legal issue with a client.
there's a whole nother field of guilt and innocence and whether someone's telling the truth or not. And my question to you is sort of off the wall, but has the field of forensic psychology or psychiatry gotten to the point where they're studying whether there are ways to tell if someone's being truthful? I mean, I know we talk about the polygraph, which is, a Ouija board, in my opinion, but is there any work done in that field? Are people studying that?
Not that I can tell by reviewing the literature. My personal quest or strategy is compared to maybe some forensic psychologists and psychiatrists. I spend a lot of time with the client. Ideally, I like to spend between 8 and 12 hours with them, spread out over, say, a 4 to 8 week period of time, so I can look for change of moods, change of presentation, consistency in what they tell me. Some of my clients think that I'm occasionally redundant, and maybe I am, but some of it is a method to the madness with trying to figure out, what's the story this time?
Sure.
And, getting them to tell me what went on in the offense conduct. You attorneys know that the more often you have them talk about something they did that was malevolent or nasty or whatever, or illegal, the more versions you get of it.
And then it takes time to build trust. It takes time to build trust too. So
that's a very important factor, especially in what I do. Yeah. And that's by the fourth meeting, by the fifth meeting, I'm it's not unusual that something major is revealed in the last few meetings that I have with a client.
Sure.
So, and in terms of overall truthfulness, it's not very scientific. It's more of an art form, I think, but based on many years of experience.
Sure.
And occasionally, like I'll look at the MMPI, which is a major personality test that I give all of my clients that have at least a high school education and have acquired that level of comprehension in English. To see in the validity scales of that particular test how they approach the test. I don't use that as a black and white kind of indicator, but I just look to see, how do they approach an objective exam? And that may give me some idea of just how forthcoming they are. But it is tricky. It's not easy.
And you talk to family members too. So
yeah, you get corroborating information. But that takes time, takes cooperation from family members. I have a case there just the other day, finally, after 3 weeks of trying to reach a parent of our defendant, I was able to get him on the line and had a wonderful conversation, found out he works for the railroad. That's why he wasn't returning my calls. He wasn't in touch for a week or two at a time. But anyway, so it's important. You get information from various inputs and various perspectives, and then you've got to put it together.
Yeah, Dr. Whiting, I'm in the Southeast. You might notice from the thunderstorms that every time we do a podcast, I have a thunderstorm coming in. I've got my fingers crossed. I will not lose power today. But we use forensic psychologists and psychiatrists in a lot of criminal sexual misconduct cases to do the MMI, the objective testing, to see if it discloses some deviant characteristic, or if it doesn't disclose some deviant characteristic, and then take that to the prosecutor and use it in sort of making the pitch that it's not this guy because he doesn't have that personality trait. Is that something that you do in your practice?
Yes, I do.
That's not the MMPI though, right? That's something else.
Well, no, you can use the MMPI for just about anything. I mean, it is the best personality test. It's objective. It's criterion validated. It's of psychological tests. It's one that's gives you a plethora of information and is relatively easy to describe and inform the court and the prosecutors about. They tend to get what the MMPI is, and they, if they want to listen, then it's kind of easy to explain. So that's a good instrument to use. But in the area, yeah, go ahead, Jim.
We also have, and I think in California you have the same, these civil commitment proceedings after someone has been convicted of a criminal sexual crime, usually child molestation, and they've served 20 years, and then upon release, they are not released. They are then civilly committed for an indeterminate period of time, because they're a danger to be on the street, and so there's testing and evaluations that are done in that context, and
we call that SVP, sexual violent predator.
Yeah,
it's just like a civil proceeding.
And Sarah was not aware of this, but it's used quite frequently and here, and it's we refer to it as the Peter meter, but there's a device that measures blood flow, and it's got a real name. I'm pulling it up. I can pull my computer.
I'm going to tell you, it's a plethysmograph.
That's exactly what it is. Yeah,
that sounds even dirtier.
Yeah.
I like.
Do you seriously call it a Peter meter? Come on, Jim.
I think that's very accurate.
There you go.
It's like it's literally a blood pressure machine for the penis.
Well,
and is that something that?
Thank God I don't have to worry about that. Y'all can deal with it.
But my question is that reliable? Is that reliable in your opinion?
I don't believe so, for a number of reasons, and it has fallen out of favor with a lot of people in my field. I don't know any colleagues in forensic psychiatry that you currently use that. Although I will say I don't do any of the SVP work, but the problem with the plethysmograph is there's a couple issues. One is you really, if you want to know, let's say you want to know if this person is stimulated by images of children, you'd really have to show them illicit, illegal child pornography to have the true effect. So scientifically, that again doesn't make any sense because you're not going to get a hold of that for sure. And then there are plenty of things that can block having an erection. There can be all sorts of things that motivate behavior, and people don't get an erection. There are plenty of sex offenders that are in their 50s, 60s, and 70s who have real issues getting erections and are still maybe they're considered dangerous. But I don't think the plethysmograph is a good way to measure that. By the way, I found out the hard way in a trial.
No pun intended.
About 10 years ago, when a prosecutor knew something that I didn't know, that the DSM-5 said that the most reliable way to assess attraction for children was using the plethysmograph. And I was shocked to learn that because it was my understanding and the way the literature goes now that it's not used very often and it's been debunked for the most part.
So on a far less intrusive way, you do testing on individuals that are facing sex charges.
Yes.
I don't know if this is something in South Carolina, but here, if we're trying to, let's say, negotiate a plea on a sex offense, the requirement is that the defendant be assessed to determine whether they're a sexual predator or not. It's whether this, in other words, distinguishing between an isolated type of incident of conduct versus somebody who has the propensity to commit, sexual misconduct. And so that is something you do, Jeff, right? Aside from the MMPI test.
Yes, I do a lot of that actually. I think the there have been times in my practice over the last 10 years where the plurality of cases was possession of child pornography.
Yeah. We've had federal cases like that together.
Either federal or state. Yeah.
So, yeah, go ahead.
No, so the issue there is to try to figure out, well, does this person have an aberrant sexual orientation? Is he oriented toward children? And if not, why is he looking at child pornography?
Yeah.
And there can be many answers to that are maybe we don't like the answers, but are understandable.
Right. They explain the behavior. They explain it.
Explain the behavior, and at the same time doesn't again make the jump, because there's a lot of times people assume, the public assumes, that if you're looking at pictures of children, you've already, or you're just about going to, abuse a child. And the truth is, something around 90% of people convicted of child pornography possession never abuse a child. And so it's important to kind of educate the prosecutors and the courts sometimes, because they don't know that. And to really look at, well, what are the chances they're going to recidivize, and do we have ways of figuring this out so we can make a pretty strong prediction?
So, Jeff, narcissism has become sort of part of our pop culture. Suddenly, everyone who acts badly, we call a narcissist. Like, if we don't know exactly what's wrong with them, we say they're a narcissist. Is there, what is the forensic definition of a narcissist? And are we really experiencing an uptick in this, or is this just something that we use to excuse bad behavior?
I can give you kind of impressionistic answers. I've got no scientific understanding of it. I mean, I know what narcissism is.
Yeah.
It's one of those things that if you spend 20 minutes with somebody,
you'll know.
You don't have to have a PhD. You'll probably figure out this person's pretty self-involved. Yeah, I have in forensic cases, when somebody comes across that way, what I conceptualize it that this person probably had major disruptions in what we call attachment history when they were young. They weren't solidly connected with maybe either one of their parents, and they were kind of lost in the world. And their kind of self-treatment, if you will, for that was to become self-focused, and almost unconsciously ruling out the understanding that relationships are important sources of getting what you need, because their early experiences rule that out.
Yeah.
They think that's too dangerous of a formula to live by. So they become entitled. They become self-directed, and they're very difficult to deal with. I mean,
a lot of therapists say, I know you don't do as much treatment as you do the forensic work, but I have friends who are therapists who say they don't treat narcissists because the narcissist does not accept that there's anything wrong with them in order to get treatment. So it makes it very difficult to,
Then I would say, why are you here?
Right. Yeah.
Why are you here?
Right.
You must be suffering. Otherwise you wouldn't be here.
Right.
So let's figure out why you're suffering.
So can we talk about sorry.
Do you have a narcissistic dog? Is that?
I do. The dog is actually a very caring dog, because there's somebody outside doing work on the windows and the dog feels like he needs to protect everybody. So it's actually the opposite of the narcissist dog. Let's talk about the ethics of what you do. At the end of the day, you are a hired gun. Typically, the defendant hires you to assess them and to present the best case scenario in their defense, in mitigation, et cetera. when you come across facts that you learn about somebody that's hired you that are really not good for their mitigation,
Bad facts.
bad
Yeah.
facts,
Bad facts.
right? Bad facts. What I mean, how do you deal with that? Do you just go, well, they paid me, so I got to put on the, I got to change the report. I can't put. I mean, how do you walk that line between, trying to help the defendant, but also being candid and not,
Sometimes the attorneys involved, when they make the referral, they warn me about something regarding the client, and sometimes that's helpful. They may warn me and tell me not to ask them about certain things, because and if it's fine with me, if it's not an area that I believe is pertinent, then I'm not going to wander into that area, because it's not going to be pertinent for me. Mm-hmm. So I sometimes find things out almost by accident, depending on where the conversation goes with the client. Mm-hmm. I think what I try to do, and I think I had a recent example of this. I try to figure out those aspects of our clients that might be disagreeable. Let's say it's not bad facts, or maybe it is bad facts, but also there's some personality quirk about them that's hard to put up with. I had a federal case a couple of months ago where the client was looking at 20 years, and it was a major fraud. I don't know, it doesn't matter, but north of $25 million.
Wow.
So the client was, the lawyer told me this, the sentencing person told me this, and then when I met him, I saw exactly what they were talking about. He was rather quick, kind of brazen, almost like skated above it all. He seemed to have that approach, was a little bit entitled. But then I found out that his background was horrendous. He grew up in an area of great conflict in Eastern Europe, had suffered terrible atrocities, terrible deprivations as a child. And it's a long story short, but in the end, I told the story of his life and how this kind of edgy, kind of strong, over-the-top personality was something he had to develop in order to survive. And to the lawyer's surprise, to my surprise, the judge thought this was a great explanation for who this man was. And I think he ended up getting 6 years, which was a pretty amazing result. Now, that shocked me, but I thought it was a difficult case because we had to make this guy human in some way when he was he irritated you around the edges. But it was. I think the strategy was tell the story about who this guy is and why he's this way. How did he become this way? Why did he need to become this way to survive? Not to steal. To steal was, an important issue, but it was his personality where nothing was going to be enough. When you come from deprivation, sometimes that's an adjustment. You can accumulate wealth and you need more and more and more, because you don't know where to draw the line and say, I don't need any more. I'm okay now.
That reminds me of I can't remember the facts, but there's a criminal case in Texas. Some young kid, I think he was just out racing in some sports car. His parents had gotten him, and the defense lawyers there had gotten a psychiatrist to diagnose him with affluenza, that he had been given too much. So he was not able to recognize boundaries for his behavior. And, that just sort of leads us to, sometimes, in my opinion, you can go too far, espousing opinions on behalf of your client that just aren't credible and they backfire. But
I agree
Jeff,
with you.
Who in your
that one, That one does not appear in the old DSM-5.
Affluenza, yeah, that's right.
Yeah, yeah.
I'm going to let the dog shut up before I ask you my next question.
But Sarah, to your point about and Dr. Whiting, I don't want you to speak to this, but I can tell you when I retain an expert, I ask them don't put anything in writing until we have a conversation. You know, I don't want them to prepare a report that I have to disclose as harmful to my client. So
Sure.
that's just how
we talk first, obviously,
Yeah.
and you know that's an interesting point because I bickered on Twitter with a lot of people over, oh, well, you're just dishonest. No, I'm not dishonest. These are my experts that I'm consulting with. I get to speak to them just like prosecutors speak to law enforcement about, you know, what they found or what their investigation is. I get to speak to my experts about what their findings are. That doesn't mean I'm influencing what ultimately goes in that report. But I might say, thank you, no, thank you, do not give me a report. I don't even want one. You know what I mean?
Yeah.
I mean, that's certainly not unethical. But I have a question. In the span of your work, what profile of a defendant do you find to be just beyond help? Like you just cannot find anything that is explainable in their behavior?
Oh, that's not explainable?
Yeah, that basically.
I'd be hard pressed to come up with one where we can't find something. I think the only requirement would be that, you know, will they talk to me? Will they answer my questions? If they won't cooperate, I have no information, or if they don't get it and they lie and make things up, and then I'm not going to be able to help them.
How often does that happen? That somebody is just
not very often,
you know,
not very often, because again, I get a select population. The attorneys involved already believe that not only does their client need an evaluation and potentially it could help the case, but they usually think that, you know, the person will settle down and actually show up for appointments or talk with me if I go visit them in jail. So it's, you know, I'm very fortunate because my population is selected for me. But if they refuse to talk, of course, and the question earlier about drug addicted, you know, under the influence, my experience is that I'm going to get nothing, and nothing of value other than to see them under the influence, which is kind of overdetermined at that point, the value of that. Usually as a strategy, if whether or not the addiction is tied directly to the offense conduct, it's a nice move pre-adjudication if you can show from the defense, if you can show that your client is motivated at least to get clean and sober.
Yeah.
So,
right.
And you know, this is interesting too, because often clients think, well, if I do go to treatment or if I do go to 12-step programs, then I'm admitting guilt. And it's like, no, you're just owning the what led to the conduct, and that you're addressing it so that you could come out better than otherwise, right?
Mm-hmm.
And it's an interesting conversation because people routinely think that going and checking into treatment means that they're guilty of what they did, you know, and it's actually the opposite. So the other question I have for you, Jeff, is, are there some crime, you know, we've been talking a lot about, this is a crime podcast, so we talk about stuff that's in the headlines. And, you know, we have that Idaho killer case where 4 people, college students, were slayed. They were stabbed with a knife. We have the recent arrest of Rex Heuermann, who's the Long Island serial killer, who apparently was meeting up with sex workers and then killing them and burying them. Are there some crimes that inherently, just by virtue of the commission of the crime itself, you say the person's crazy? Or is that stigmatizing mental illness?
You know, I try to be responsible about making comments that, especially on cases that I don't know much about. I know what my wife knows watching the news about some of these cases. I
Right.
haven't delved into it anymore. I'm always curious. If I hear something in the news, and I say to myself, boy, it'd be interesting to sit down for 8 hours with that particular guy and the man in Idaho and find out what his life is about. I don't know what I'd find. Maybe there's nothing there.
No.
Maybe it'd
Well,
be
we know he
shocking.
was a heroin addict at some point, but
Oh.
not maybe not.
Mm.
There's so little known. That's also the problem, is that we don't know a lot. We just know what they're accused of, and then everyone's trying to figure out, he has all these like personality things that match a serial killer. It's like we don't even know the guy. We really don't know much about him.
Well, Sarah, it seems to me that the FBI has, criminal profilers where
Yes.
they try to develop a profile for someone who's a serial killer. And if, they've arrested someone, accused them of that, I mean, I would think someone like Dr. Whiting could go in and do an evaluation and say, no, this person does not meet the profile of a serial killer. I mean, I don't know if you've ever been called upon to do that, but if what's good for the goose is good for the gander, in my opinion.
Yeah. No, I'm always fascinated. I mean, the famous book that was written, 30 years ago by the FBI profiler, John, I'm blocking on his name, a fascinating study. And it was the first book from that unit in the FBI. Right. I was just fascinated by it. But
what is the difference between, people always ask this question, insanity, because sometimes for small percentage of cases, our client is not guilty by reason of insanity, and we put that up as a defense essentially, and incompetence, where we find cases pausing and starting and pausing and starting because somebody's incompetent, but then gains competence. So what is, for those viewers who don't know the difference, there's a huge difference, Jeff. What is the difference between not guilty by reason of insanity or the state of mind of insanity versus incompetence?
Well, I know that you and Jim know the legal difference of that. I'll tell you from a psychologist's point of view, and I tend to oversimplify things probably. Competency for me is quite regularly whether the person, when we get into the adjudication process, whether the person is able to cooperate with counsel, understands what's going on in the courtroom, and I'm going to say who the good guys and bad guys are, kind of thing. Who's after him, who's defending him, who all the players are, what roles do they play, and whether the person is in a mental state where they can talk with their attorney, go over discovery with the attorney, discuss strategies, and seemingly at least at a basic level understands that stuff. Mm-hmm. The NGI, not guilty by reason of insanity, my understanding of that, and I've got a case right now where this is very relevant, has to do with the state of mind at the commission of the crime. Mm-hmm. So let's say we have a murder, but our client was, we believe, psychotic, and suffered from a very severe paranoia psychosis, and basically killed this individual who kind of wandered into his territory, who presented to our client, either accurately or inaccurately, because our client was misperceiving reality at the time, some danger, some threat to him, which our client neutralized. At least he thought he was protecting himself. That's what he told himself. He was out of his mind, and we have videotape of him interacting with the police and with his first interview at the station, where he's still very psychotic. And but in that particular case, that occurred many years ago, and we're still moving through the case. I think because we've had time, and because the client's family had resources, the client was treated and is in a good, stable psychological condition right now. Still have some remnants of the psychosis, but is stabilized on a pretty strong medication, but is able to live outside of custody and outside of hospitalization. So I think that's in my view, that's the kind of difference between those two categories.
I also say from a lawyer POV, I say insanity refers to the past. At the time of the offense, your state of mind was such that you were insane. Incompetence deals with the present, is whether you have the state of mind to understand all the things that you described currently. So one is past, one is present. I've had this issue in one case, and this recently came up on the East Coast with postpartum depression. Again, this seems to be another condition that people think it's just a mom excuse, or like it's not a real thing. And this woman on the East Coast, I guess, killed her 2 babies, and then tried to commit suicide by jumping out of her window or something. How serious is postpartum depression in the context of, somebody committing a crime?
I had never had a postpartum case, probably in the first 15 years that I was in the field. But I every year I went to a lawyer's meeting, and I made friends with a man. I'm blocking out his last name, but his first name is
You
George.
mean the lawyers meeting in Aspen where everybody's having fun drinking and skiing?
No, we're chatting. We're chatting about cases. We're not doing any of those other things.
Not when I see you there. Right.
I go for the skiing. That's all I go for. But I met this attorney. He had been somebody who socialized with me, and he represented Andrea Yates, who was the woman in Houston who drowned all her children.
Right.
And I, by virtue of that experience with George, telling me that no, this is the real deal. Somebody can be rendered psychotic due to hormonal imbalance, due to postpartum issues. So while I think I've had only one case of postpartum. Thankfully, the woman did not commit a horrendous offense, but that's a serious disorder that needs to be medically treated and diagnosed. And it's unfortunate because almost by definition, we learn of the significance of this after something terrible has happened, because the mother is acted out.
I've been around depression and anxiety in someone very close in my family who just was not on the right medication. And I literally thought, I'm going to lose her. I thought she was going to take her life. I didn't think she was going to go kill somebody, but she was not. I mean, it was like, speaking of insane, I thought I'm dealing with a completely, she was out of her mind. And it's very serious. And I think that so many Americans suffer from depression and anxiety that it's like we said, like the forgotten disease, because it's such a wash because everybody has some form of it, taking some sort of a cocktail for it. But it's a real thing. And I mean, in this case, we're talking about postpartum depression, but nonetheless depression. I guess our message is that every mental illness is a serious illness. It's just the level of severity varies, obviously.
Yeah, and the level to which it disorders our lives.
Correct. Exactly. But I mean, Chris Cuomo says when you have a cough, you take medicine for it. And there's this, for some reason, we struggle with admitting that we suffer from a mental illness, or we don't want to know if we do, and we certainly don't want to treat it. And that's part of why we see a lot of things happen when it's too late, like you said. But I want to leave with this. I think viewers are always, and listeners, I forget that we have listeners as well, are always interested in your practical experience, right? Like, so what is the one thing in your career and all the years that you've been doing this that you think is a big success story? And what is I know there's a lot of travesties because we're in the travesty business, but what is like a big travesty that you just will never forget?
So we can end on a positive note. I'm going to start
Sure.
with the bad thing first.
Okay.
You've had experience being interviewed before. I like this. Good job.
I had a case several years ago where the person stole money, and we were trying to figure out why he stole money. He had a clean record, and he was looking at 5 years in federal, the Bureau of Prisons, with the feds. And as lawyers know, of course, that the guidelines, while not the federal sentencing guidelines, while not mandatory, certainly are advisory, and it's hard to get a sentence outside those guidelines. So that's what we were hoping for. We were hoping to get under the guidelines. We had what I thought was a very sympathetic case. He had family issues where he had to take care of his ailing wife who was quite sick, and he was her caretaker. And one of the reasons he had done this because his own career had taken a nosedive, largely because he had to spend so much time with his wife. He couldn't afford to hire care that she required. I think that was a mistake because, but that's beside the point. That is what he did. And he stole the money because he was panicked. And he was looking at 5 years. I thought our presentation was excellent.
How much did he steal? How much?
How much did he steal?
Mm-hmm.
Is that what you asked?
Yeah.
I think about $700,000,
Okay.
of which 600,000 of it was recovered.
Oh, okay.
So the argument was the loss was 100,000, not 700,000.
Right.
But anyway, he ended up getting 4 years. So he didn't get 5; he got 4 years. But I was hoping for, a much bigger departure for family reasons.
Was he abused or no?
As a child?
Yeah.
I don't recall. I just know this is a man who was under tremendous pressure and made bad decisions, used poor judgment.
Before you get to Jeff, before we end on the positive note of a highlight, because I meant to ask you this earlier. When in my early days when I did a lot of like misdemeanor sort of cases, theft cases, I came across, and you and I have had this discussion before, but I can't remember what your response was. I came across a lot of men who had experienced some form of loss that would steal, that didn't need to steal. So for example, one thing that comes to mind is I had a 41-year-old man who had just divorced, was kind of devastated by the divorce, right? And that's some form of loss. And
Sure.
He went into like Sam's Club or whatever and stole CDs and magazines. Like the whole thing added up to, I don't know, $30 maybe. And of course your assessment was like, why would somebody like that do that? But I find that there is this correlation between males who experience a loss, whether it's death or divorce or whatever, and then theft. And I don't know if there's any psychological explanation for that. Matt, don't steal.
Well, they lost something, and so now they got to recover. They got to make up for that.
Okay.
They've been shorted, so now they need to get a surplus.
Interesting.
I mean, sometimes I know this sounds crude, but it's simple math.
Right.
Something was taken from me. Now I deserve to get something back. That's hard to get to because that's kind of deeply unconscious with a lot of people.
Right.
But you see a lot of repeat shop
lifters
mm-hmm. who, I've had several fairly wealthy women, and I like to tell their defense counsel when they call me with the referral, that the diagnosis is going to be a bad marriage, because a lot of them are just acting out against their controlling husbands by stealing things they don't need to steal, they can afford.
Yeah.
But to really get themselves into trouble and call attention that they're suffering. So
all right,
they're
so
suffering
tell
in
us
the marriage.
the highlight.
The highlight was a case about 3 years ago. It was actually, I watched it unfold. I won't tell you too much because it'll give away, but I actually watched it unfold on live television when I was in another city. And it was a very violent police pursuit. And my client was a woman, and she was charged in this for accessory after the fact murder, and she was charged with felony evading. Her cohort was the one who was charged with murder ultimately, although he died. But anyway, this was a high profile case, very, very difficult case. And we got lucky in this one, I'll say, because the court was patient. It was during the pandemic, and decided that they would spend time. We were the only courthouse open. And he would spend time listening to us tell him why we thought our client should be in mental health diversion. And she had a history of being physically abused by her older sister. She had a torturous history of 4 or 5 relationships as a young adult. She was, I think, 35 when we've got her. But prior to that, about 5 abusive relationships, bad, where she was, would be beaten, bleed, have to go to the hospital, get a bone set. But in the end, this last one, boyfriend that she was with, was the most violent of them all, and horrendous history. So we hired an expert to talk about domestic violence in partnerships, yes, and then I testified about all her background, and the judge was patient. He spent several days listening to us, and then did.
He had nothing else to do. I mean. During the pandemic.
Well, he could have stayed at home. I think his court staff wanted to be at home.
Yeah.
But anyway, the outcome, we're not finished with diversion yet, but it's looking very good that she's going to get out from under at least one very serious charge, and the other one she may get reduction from the felony. But
when you say it was on
so
TV. When you say it was unfolding on TV, meaning when you were watching it unfold on TV, you did not know that person was going to end up being your client, right? Your patient.
No. I was in a bar in Las Vegas, and I was watching this car chase. So,
all right. Crazy. Well, you guys have anything else for Jeff?
No, I really have enjoyed it, Dr. Whiting. Thank you so much for coming on.
Yeah, thank you so much.
You're welcome.
Yeah. Jeff, thank you so much for joining us. And, these issues always come up. And so I hope that you'll allow us to rely on you when something else comes up and we need your expertise. We can call you and have you back.
This was fun. I'd be happy to return.
Thank you, Jeff. Take care. And we're going to be back next week with a new episode of The Presumption, Jim. So until next week.
We rest.
We rest.